Bridget, Executive Editor, Wian Tan, what a great job you've done. Dean George Williams, John Pavlakis, the partners at Ashurst. Thank you to all of you assembled here, friends, colleagues and others. Let me start by congratulating you on yet another outstanding issue of what is truly one of the most highly regarded law journals in Australia. I was so impressed with the quality of the work in it, and it's only today that I actually got to see the whole issue, or yesterday, but I had been sent the proofs of the thematic issue, and all of the articles are just absolutely outstanding. I'm certainly honoured to have been asked to launch it tonight, where my focus is going to be, given the gender focus, on the thematic part. But as I said, all of the articles are terrific. There's a certain sense of satisfaction, a sense of place and even rightness in launching this, because, as Bridget mentioned, it's, believe it or not, next year will be 30 years since Law and Gender was first taught at UNSW Law School back in the day. So it seems particularly fitting that UNSW Law Journal is publishing this issue. Things were different. John talked about the clothes and the hairdos in 1987. One of the major differences was a very large number of people in this room weren't even born. High Court judges certainly weren't familiar with the idea of a course called Law and Gender. I recall vividly a young man in that first class regaling us with tales of his interview with Justice William Dean of the High Court as he showed him his transcript and explained the subjects he was doing. He was like, what's this law and gender? But apparently Justice Dean found it all very interesting, and he certainly got the job. And another woman from the class became associate to Justice McHugh. And then they got married, and then they had 4 what we call law and gender babies, who are all grown up now, and I'm reliably informed that at least one of them is studying law at UNSW Law School. So there you go. In the foreword, which in keeping with the theme, I guess, that was raised earlier, which was written in Los Angeles, does that fit with the other, actually Santa Monica, but who's counting? I've set out a very brief account of the development of some of the specialist publications about law that have as their focus the theme of gender, or are published from a feminist perspective. And I just want to say this thing about special versus general has always been a theme. Going back to the teaching days, I always remember the issue of the people coming up and saying, oh, will you teach a class for me on gender? Because I don't know anything about that. And one of our ambitions was to have that become a normal part of a course, not some special thing that only a person, you know, with horns and who was otherwise labelled feminist could teach. So I don't really read too much into the fact that this is the first thematic issue, because the important thing is that work has been being done for some time in this area. But it's still wonderful to have it all gathered together into this particular part. So in the foreword, I talked a bit about some of those journals and also the odd special issue, and recounted a little of the history of the book that Bridget mentioned, that Jenny Morgan and I did, The Hidden Gender of Law, which we first published in 1990 and did another edition of in 2002. And that book grew out of teaching the course at UNSW, and then in turn was used as pretty much a teaching text. Now, we wrote that first edition at a time unthinkable to most of you, when there was no internet, or certainly hadn't reached law schools. There was no email. There were just starting to be thermal paper fax machines, which some people might remember. Jenny got a laptop. That was really exciting. It was sort of quite a bit bigger than what we would now think of as desktop computers. And we had things called floppy disks. And if you were really lucky, they had the capacity to put one chapter on. And then we would go to the post office and put them in a little posting case and post them to each other in Sydney and Melbourne if we weren't physically writing in the same place. Even the difference between the first and second editions was astronomical, and the second edition was, 14 years ago. So things are a lot easier now. You can write your things in hello. But so much for ancient history. We describe the hidden gender of law as both a law book and a book about law. We saw it as a mechanism for opening a debate about questions such as what is a gender issue, about legal categories, and about the role of legal categories in perpetuating gendered stereotypes. We were particularly concerned that categories limited the way we thought about gender, and to that end, we didn't have chapters called crime, tort, contract. Rather, we organised the book around themes that were important in women's lives, like money, like work, like women's bodies, and gendered harms. The thematic issue which we're celebrating the publication of today engages with a number of the types of issues that we have been concerned about for these past at least 30 years in law schools. Emma Henderson's and Kirsty Duncanson's article on jury directions in rape trials starts by reminding us of the long history of legislative reform in the area of rape or sexual assault law. And I say sexual assault law, that's what we call it in New South Wales. Their article, it's in Victoria, is about rape law. As an aside, one of the key legislative reforms we have undertaken in this area, Professor Stubbs will correct me, I think it was 1981, was it, when we took the rape out of sexual assault and we replaced out of the crime, and we replaced it with the more gender-neutral idea of sexual assault. Now, of course, gender neutrality is itself a way of masking the gendered operation of legal doctrines and the gendered nature of lived experience. Just to give you a really, perhaps one of my favourite examples of how this can work is there was a publication that decided, we're going to be gender neutral. So the way we're going to achieve that is we're going to use alternating pronouns by chapter. So the chapter on sexual assault had the rapist, she, because that was, was the next chapter. Yeah, right. So there's a long history going back to the Henderson and Duncanson article in both policy and academic research that demonstrates, rather disappointingly sometimes, how limited has been the impact of the many legislative reforms that have occurred in the field of rape law. And in this article, the authors actually give us some scope for at least cautious optimism about the legislative reform they're writing about, which is the timing of jury directions on consent. They suggest that if that's done at the earliest possible time in a trial, rather than at the end, that may have an impact and affect, it may dispel some of the harmful rape myths that persist. Kate Gleeson theorises about gender justice in the context of child sex abuse in the Catholic Church, something we've heard a lot about in recent years with the Royal Commission on child abuse in institutional care. Reading her most interesting and timely article reminded me of a moment in time in the early 1990s when the Ontario government in Canada actually set up an explicitly feminist adjudication and redress process to respond to historical harms that had happened to a group of young women and girls in institutional care in the 60s and 70s in Canada. Now, I don't think, in my old age cynicism, we're going to see a process like that come out of the Royal Commission, or perhaps at any time in, my lifetime. But what's so important is that we have a model that we can draw on. And there are other examples, such as the Women's International War Crimes Tribunal that some of you might know about, that was established to, in effect, provide a people's forum when the Japanese government wasn't doing anything about comfort women. Shelley Bealfield's article about income management and its particularly harsh gendered consequences for Indigenous women provides a timely reminder of a significant shift that occurred in feminist legal scholarship, from the earliest over-enthusiastic days of talking about women as some loose, undifferentiated group, to the key understanding that women, while they might broadly share some elements of their subordinate gender status, are as varied as it is possible to be. They vary by race, by class, by sexual orientation or gender identity, by religion, by physical ability. And it seems unimaginable to us now that it was only in 1989 that Professor Kimberly Crenshaw introduced the language of intersectionality to the way we talk about those differences. Of course, we'd always known that women were not the same, but intersectionality gave us a term and a language in which to express that, in much the same way that by having a label or a focus, Catherine McKinnon once explained, sexual harassment, the event, is not new to women. It is the law of injuries that it is new to. Eileen Kennedy's Fixed at Birth is a piece about the historically immutable gender binary that has permeated both popular and legal discourses, but it's very much subject to challenge at present, both legally and politically. We need only think about the bathroom law debacle that's going on in North Carolina in the United States. And she also reports on a decision of our own High Court recently in Norrie's case, where the court recognised that in New South Wales a person may be noted on a birth certificate as non-specific, which is what Norrie was seeking to have the court decide. Rosanna Bricknell writes about the phenomenon of employer-sponsored oocyte cryopreservation, which is a very 21st century form of control over women's bodies. Now, control over women's bodies, and in particular over their reproductive bodies, has been a key concern of feminist legal scholarship since its inception. And it was both timely and sobering to be reminded in June of this year by your own Dean, Professor Williams, that abortion remains a crime in New South Wales, which a lot of people don't seem to know. I know one of my colleagues at the bar looked at me as if I was telling him something crazy until I actually had to draw his attention to the relevant provisions of the Crimes Act. It's there in the Crimes Act, subject only to a common law defence of necessity. Well, like many other people, I have been absolutely riveted by the United States conventions that are going on at the moment. And I gave myself an excuse yesterday to spend a lot of time watching it, because when you read the foreword, you'll see I've referred to somebody who was there. So amongst the many hours I spent, don't tell anyone, watching this, I did watch a speech by Massachusetts Senator Elizabeth Warren. Now, for those of you who don't know, until 4 years ago, she wasn't Senator Warren, she was Professor Warren of Harvard Law School. And in fact, that professor thing really doesn't go away. In the New Yorker online this morning, there was a story that said after her speech, she then gave a PowerPoint presentation. Seriously. explaining all the financial stuff that was going on. And apparently she was quoted as saying, "Once a teacher, always a teacher." Now, in her speech yesterday, you might have heard her, if you, like me, spent wasteful time watching it. She talked about Donald Trump's 6 bankruptcies, about which she said bankruptcy had allowed him, in her words, to protect his own money and stick his investors and contractors with the bill. That's what she said. Now, she knows a bit about bankruptcy. That was her area of expertise at Harvard Law School. And in 2002, as a bankruptcy expert, she published an article in the 25th anniversary edition of the Harvard Women's Law Journal, which is now called the Harvard Journal of Law and Gender. And it's called "What is a Woman's Issue? Bankruptcy, Commercial Law, and Other Gender-Neutral Topics." The particular focus of that article was her concern about a then pending, and which was ultimately enacted in 2005, legislative initiative, a bill, that was designed to impose significant restrictions on consumer bankruptcy. Her concern, a concern echoed by a large number of women's organisations, 91 law professors who wrote a submission about it, was that the proposed law would have a disproportionately negative impact on women and the children in their care. She was involved in a long-running empirical project called the Consumer Bankruptcy Project, which had reported in 1981, 1991, and was about to report its 2001 data. And she found in the 2001 data that divorced women and single-parent woman-headed households constituted 40% of all consumer bankruptcy filings. And when you included women who filed with their husbands, the number of women who filed for bankruptcy in the United States in 2001 was, believe it or not, 1 million women. The project's data showed that women filing alone for bankruptcy, that is, that 40%, the divorced women, woman-headed households, was the fastest growing group, and their numbers had increased by 800% in those 2 decades. She thought the data was wrong. It had to be wrong. The figures were too extreme. And they went back and they did the data again, and that's what the numbers were. And of course, they interviewed all the people. The motivation behind most of these women's bankruptcy filings was what she called one significant event, a serious interruption in income, usually either a job loss or significant illness. And of course, in the United States, with the, certainly until the Affordable Care Act, significant illness often had a very major financial impact. But she started the article by focusing on another person who we're going to see on television tomorrow, and who was in Sydney a couple of weeks ago. I nearly got run down by these screaming motorcycle police, and thought something terrible was happening until I saw all the black tinted window limos, and of course it was the Vice President of the United States, Joe Biden. She starts the article by saying, in 2001, the National Organisation of Women celebrated Joe Biden. He was the only politician referred to in their annual report. They had a picture of him with some of their board. He was a champion of the women's movement because he helped them in relation to his support for the Violence Against Women Act. But she says the annual report didn't report all his legislative achievements, among which she included his efforts on behalf of the credit industry to increase restrictions on bankruptcy. She said, given that this legislation was going to affect women so disproportionately, she wanted to know why he wasn't getting the same attention. Why wasn't he in trouble with women's groups for his promotion of the bankruptcy legislation? Now, of course, that legislation was gender neutral on its face, But 29 major national women's organisations had written opposing it, and she lists them all in a footnote. They go from, of course, now itself, the National Organisation of Women, which was celebrating him in its annual report, but YWCA, Hadassah, Church Women United, you know, these are not just radical, small feminist groups. These are national major women's organisations, the National Black Women's Health Project, National Council of Jewish Women. More particularly, not one women's organisation supported the legislation. But the American Bankers Association described itself as lucky to have Biden in support, and she has a list, a string of footnotes of media articles saying that his support was pivotal, it was the linchpin. To quote her, "Without his sponsorship, it is widely believed that a hard-to-explain bill that favours big banks over families in terrible financial trouble would be dead. More importantly, because he expressly rejected concerns raised about the bill's effect on women, he has shielded his colleagues on both sides of the aisle from being branded as anti-women for their support." She says it's his support of legislation that helps women and his even more vigorous support of legislation that hurts women that makes her pose the serious question, what constitutes a woman's issue? And that is the bit that leads into the paragraph I quoted in the foreword, where she says, she answers her rhetorical question by saying, some issues tied to physical differences between the sexes, abortion, birth control, sexual assault, breast cancer, are clearly labelled women's issues. Other issues close to the hearts of many women, child abuse, childcare, elder care, child custody, women in poverty, also make it to the top of the list. Economic issues focusing on equality, equal pay for equal work, equal employment opportunity, equal educational opportunity, find their champions as well. But business and economic topics are often overlooked. Even when women's groups become involved, these issues never seem to become a priority. Moreover, when business topics are on the agenda, there's often a well-funded business group pressing its own interests, drowning out the voices of women. Now, as I said, Senator Biden categorically, Vice President Biden, rejected the claims of the women's groups, and indeed he went on the offensive. There was this very tiny amendment, which I don't want to go into detail, that he sponsored and then was able to put out this big press release, the bankruptcy bill will not disadvantage women and children. And Senator Warren clearly explains how that was just absolutely insignificant in the scheme of things. So I really recommend you read it. And of course it also had resonances for me with Shelley Bealfield's article about income management, because she refers to organisations such as the Australian Law Reform Commission specifically cautioning against the way it was going to be about the process itself and pointing out what would be the negative gendered consequences. But of course, those concerns were completely ignored. It's not seen as a gender issue. Warren notes that this dissonance between the recognition of violence against women as a women's issue, but the failure to accept that an issue like bankruptcy is, raises a troubling spectre of women exercising powerful political influence within only a very limited scope, such as rape laws or equal educational opportunity, but wielding little influence in business or other supposedly gender-neutral areas that profoundly affect many women. And the same is, of course, true in legal discourses. What we recognise as an issue in law affected by gender is also profoundly limited in the same way as it was possible for then Senator Biden to assert that the bankruptcy bill would not harm women, notwithstanding what every woman's organisation was saying, which sounds to me like a bit of mansplaining. Now, I don't want to be seen as on an anti-Joe Biden rant because, in fact, Bridget mentioned, I think, what is his name? Brock Turner, Stanford rape situation, and Vice President Biden, you know, wrote a very profoundly moving open letter to the woman who was assaulted in that case. Like, this is a guy who actually genuinely appears to get violence against women. From his position as Vice President, he didn't have to write that. That was a really impressive move on his part. So more power to him. But that makes it even more bizarre that he doesn't get how something like bankruptcy, otherwise apparently gender neutral, can have such negative, genderedly harmful effects. Anyway, so if there's a takeaway from this, I just want you all to think about some area of law that you've never imagined is affected by gender. And how many of you have done international law? Okay. Well, there you go. I won't even go there. It's all right. Other than to say that three then Australian feminist legal scholars won some major big prize from the American Society of International Law for writing an article called Feminist Approaches to International Law at a time when nobody could have imagined that international law had anything to say about gender, and some people probably still think that. So go away and think about it. Next time you're in a class about something, think about, you know, what might be the gendered impact of what looks to me like an otherwise facially gender-neutral law. How have gendered stereotypes affected how that legal doctrine has developed? Not least, you might remember that since only men even were allowed to be legal actors until relatively recently, and women didn't even vote, how has legislation been drafted? How has common law developed on the experience of a fairly skewed pool of the population? But that's an ongoing project. That's not our work tonight. Our work tonight is basically to celebrate the publication of this wonderful issue, both the general and the thematic issue, and I am really impressed by the extraordinary quality of the work that's gone into it. So please join with me in congratulating the editors and all the authors and all the editorial workers and everybody who had any role in making this wonderful collection of contributions to legal scholarship see the light of day, the light of sunset this evening. Thank you.